dismissed. So the defense is saying that Margaret, the parents, that upon seeing the body at the hospital, and then of course the defendant's false narrative, that was an intentional infliction of emotional distress. So that's like, see how they said in there that the defendant's false narrative. So basically, they're trying to argue that that's the intentional part. I don't think that's going to fly, but that could be that the judge may say, I'm not sure, but the judge may say, well, that's up to the fact finder, the jury, whether that was intentional or not. So keep going. All right.
This is more.
Yeah, no. So this is basically the law. So we're talking about Massachusetts rules of civil procedure provides that a defendant may move to dismiss a complaint if it fails to state a claim upon which relief can be granted. So they're saying basically the court must accept as true all of the factual allegations at this point to see if, even if everything is true, this still would gain muster under the law. So that this is part of the law, and in every memorandum of law, this is something very standard, that all the cases that support what the law says. So even when I used to work for a big insurance company, and we would have to deal with all these types of motions all the time, and these are standard cases that we would put in our motion. All right. You can keep going. So this is just the law. Okay, so argument. The argument, so this is the way all motions are. So this is the argument phase. Margaret and John O'Keefe's distress claims are subsumed by the wrongful death statute. So the complaint does not identify that the decedent passed with a spouse or child, meaning the persons entitled to any wrongful death damages are the next of kin. The next of kin are the decedent's parents. That's true. So with respect to the claims that may be asserted on behalf of the decedent's parents as next of kin would be a person who, by his negligence causes the death of a person, shall be liable in damages in the amount of the fair monetary value of the decedent to the persons entitled to receive the damages recovered as provided in Section 1, including but not limited to compensation for services, protection, care, assistance, society, companionship, comfort, guidance, counselor, and advice. So these are some of the things that the law allows the parents to recover. So they're not, it's emotional distress is not in there, right? So then, next they talk about Margaret and John O'Keefe allegedly experienced an emotional reaction caused by the death of their son. As next of kin, their claims for loss of consortium are factored into the decedent's estate's wrongful death claim and may not be duplicated. So basically here, the defense is saying they're technically duplicating, they're asking for the same thing. So do you understand that part? So they're basically trying to get rid of any duplication. And now they're explaining the law. So we can keep going. Okay, so now the plaintiff's emotional distress claims fail as a matter of law. So this is an important part of the argument. Negligent and or reckless infliction of emotional distress without providing context for what conduct within each count applies to what claim. Example, the elements of reckless infliction of emotional distress are markedly different from that of a negligent infliction of emotional distress because reckless infliction of emotional distress contains the same elements as those for intentional infliction. And you can keep going.
Yeah.
All right. To prevail, this is key, to prevail in a claim for intentional infliction of emotional distress, the plaintiffs must prove, 1, that the actor intended to inflict emotional distress, or that he knew or should have known that emotional distress was the likely result of his conduct, that the conduct was extreme and outrageous, was beyond all possible bounds of decency, and was utterly intolerable in a civilized community. 3, that the actions of the defendant, Karen, were the cause of the plaintiff's distress. And 4, that the emotional distress sustained by the plaintiff was severe and of a nature that no reasonable man could be expected to endure. So that's a statement of the law in Massachusetts as to the parents, if they can actually prevail under this claim. So what do you guys think? Do you think they meet the standard under
So I have a question on this.
number
Yes.
2? Yeah.
So one of the main things that we talked about in terms of trying to charge Karen with second-degree murder was the thing that was the most sure way to show it was the reckless endangerment, the third prong of it, where basically once she made the decision to put the car in reverse while drunk and slam the gas, then she's responsible. Does that same standard still apply here? Because it sounds
Yes.
it's not explicit. It's not explicitly stated.
Well, but you got to understand, this particular motion does not address that. This particular motion assumes that that's a fact, like assumes that that's true. Okay. So this specifically addresses the emotional distress claims under the law.
Right.
So we're assuming that, that she, that Karen Reed, committed the act. She knew that it was a dangerous act. She knew that stepping on the gas when John O'Keefe was standing a certain distance behind her could possibly cause him, serious bodily injury or death. So that's already assumed, Kevin. But but if we go back, can you scroll back a little bit?
Yeah, sure.
So I think the key that we're talking about here is, so right there, to prevail in a claim for intentional infliction of emotional distress. Now, this is intentional. The plaintiffs must prove that the actor intended to inflict emotional distress or something that she knew would have caused emotional distress. And that 2, this is key, number 2 is key, that the conduct was extreme and outrageous. So was this conduct arise to the level of being extreme and outrageous, beyond all possible bounds of decency, and utterly intolerable in a civilized community? Now, that's pretty significant.
Yeah, that's what I was looking at, and saying this sounds like the reckless endangerment, but if the wording is different, so just trying to make sure. I just wanted to point that out.
But
it's
like
similar. It's very similar.
Yeah, it shows that the standard for intentional infliction of emotional distress is very high. I mean, that's hard to prove right there. So, I don't know as they'll make that, but we can keep going.
Okay. I think this is where we left off right here, right?
Yep.
To prevail in a claim for the negligent infliction.
So here we go. So that was the intentional infliction. This is the negligent infliction of emotional distress. The plaintiffs must prove 1, negligence, 2, emotional distress, 3, causation, and 4, physical harm manifested by objective symptomology, and 5, that a reasonable person would have suffered emotional distress under the circumstances of this case. This applies to the parents.
And the defense has chosen to underline causation.
Yeah. So you have to hit every single one of those elements, and to prove, by a preponderance of the evidence, this is a civil case. So that's going to be tough. So the complaints.
Well, the fact that they underlined 3 tells us they're kind of accepting 1, 2, and 4, and 5.
They're not accepting anything.
Well, if you're underlining 1 and you're not underlining the others, I mean, there's no question that Karen's now been convicted of DUI, so there's negligence right there. There's no question that John's dead, so there's emotional distress right there.
Well, there's not necessarily emotional. I mean, it's basically, it's tough to get, they'd have to prove that on behalf of the parents, but anyway.
Okay.
Okay, so let's keep going. The complaint's failure to specify the factual allegations in support of the different emotional distress claims warrants dismissal, or at the very least, more definitive statement. The argument aside, counts 10, 11, and 12 appear to claim reckless infliction of emotional distress based on the defendant's alleged formation of a false narrative and the negligent infliction of emotional distress based on certain plaintiff's observations of the decedent's body in the hospital after. So we can keep going.
Yeah. Kate, are you still here? Do you have anything you want to comment on, or
Oh,
or
yeah, I'm
anything
still
you're
here.
observing?
No.
Do you want? Is there anything you'd like to add?
No. I think you're covering it. Yeah.
The plaintiffs cannot present a claim for negligent infliction of emotional distress because their claimed distress was not contemporaneous with the alleged accident. So here's that zone of danger thing that comes in, right?
Yeah.
So they didn't witness John being struck by the car. So no plaintiff directly witnessed the defendant's alleged negligent conduct. The alleged vehicle strike that is claimed to have occurred between 12:11 and 12:36 on December 29th, 2022, January 29th, 2022, the decedent himself until at least 7 hours after the incident. So they didn't see this. Massachusetts recognizes claims for emotional injuries by parents and close relatives arising out of their witnessing an accident to a loved one. But the plaintiffs must show a substantially contemporaneous knowledge of the outrageous conduct and severe emotional response. So again, they're citing the law. Only a bystander plaintiff who is closely related to a third person directly injured by a defendant's tortious conduct and suffers emotional injuries as a result of witnessing the accident or coming upon the third person soon after the accident states a claim for which relief may be granted. So this is key. The close proximity of time between the alleged harmful event and a plaintiff's claim for emotional distress must be near instantaneous, right? So then they cite, for example, they say a mother who learned of her son's passing by telephone 7 hours after the event and was not at the stress of the event could not pursue a claim. So that's a Massachusetts case that they're depending on, right?
Interesting. Yeah.
So here, Margaret, Paul, and John O'Keefe II each allege that sometime after this, John was transported to the hospital, or at least 7 hours after the alleged vehicle strike, based on the factual averments, they observed that their adult son, brother's body in the hospital. So this is 7 hours later. There is no allegation that any plaintiff observed the alleged vehicle strike itself, or that the plaintiffs were within the vicinity of 34 Fairview Road when it occurred. Moreover, the plaintiffs claimed shock was not experienced immediately after the occurrence, but rather at least 7 hours later, removing it from the scope of requisite temporal proximity. So I agree with the defense there. What do you guys think?
Well, this is just one angle of the lawsuit, though, right?
Yeah. Oh, absolutely.
Yeah.
This is just one little
Right.
count. But as far
Right.
as this one little count
Right.
goes, what do you think?
Right.
I mean, so the plaintiffs rather have a rebuttal to this, and they're essentially saying that although it's not immediate, her action, there's a causation there. I'm interested to see where it goes. I really am, as far as because I could see it go either way. I think that where it may be problematic, though, if I'm not mistaken, you can correct me, Margaret, is that this is a wrongful death case. So I think that does that kind of constrain the emotional damage.
What do you mean?
So because they're essentially saying, we're suing you for wrongful death, and as a result of that wrongful death, the emotional, the infliction of emotional distress here, does that kind of constrain that emotional distress to the immediate incident of the death?
Yeah, so you look at so basically the theory behind these types of cases, if you think about it, right? The theory of the law is if that think of all the lawsuits we could have if they didn't narrow this down a little bit, right? So we're as far as wrongful death is concerned, yeah, they have other claims where they could more likely prevail on. But emotional distress, right? If you think of all the lawsuits out there, and when does that real emotional distress, like intentional, reckless, or negligent infliction of emotional distress, when should that, where should the courts draw the line, right, Kate? So like that's why they talk about the proximate zone of danger. You're a relative, and my God, you witness your child being killed in an accident. You would definitely have a cause of action for that. You would definitely deserve compensation for that if you could prove your case, right? So, if somebody's if you've got a big tractor trailer truck, and this was an actual case in Massachusetts, actually I think it was on the border between Massachusetts and New Hampshire, but the tractor trailer truck driver rear-ended this family as they were stopped at the tolls, and the entire family was killed except for one person, I think the dad. Now, he would be in the zone of danger and obviously the tractor trailer truck was proven to be negligent, right? Because, he's the driver, and the company was sued, obviously, because they rear-ended this family that was going up skiing in New Hampshire. Now, the father was the only one that survived, but he witnessed, the other family members all dying. He witnessed them bleeding. So he was able to get money damages for, at least negligent infliction of emotional distress, reckless.
What if he had been unconscious?
Well, if he was unconscious, then that would
went
be
into a
different.
coma.
Right, then he would likely not receive those damages. Okay, so but let's say he's awake, okay, and he's conscious and he sees this happening, then he would be entitled to damages for that horrible emotional infliction. That's emotional distress. But yeah, Kevin, if he's unconscious and he didn't see any of it, then he would likely not be entitled to those types of damages.
So John's
that's
niece,
where I'm coming from.
The damage was the emotional damage with John's niece. That was well within the 7 hours.
Well, but she also didn't witness the accident. So that's still a claim that's shaky.
Mm-hmm. But she was told that John was in something, whatever Karen said, John's dead, right, or John's in grave danger, or.
Yeah.
Okay.
Yeah. And the fact, yes, I see Claudia, she was drunk, she hit him and left him to die in the chat. I agree. So for this motion, right, they're assuming that fact is true, but they're looking at the law to specifically address these counts.
Right.
So,
okay.
So, and it's hard it's funny. It's interesting. So you really have to separate out the law, and, because if you see the broad picture, the courts, think of all the damages the courts would give it if they extended emotional distress claims for people who were not at the scene of the accident. I mean, it would be opening the doors for a lot of liability.
And so the response to this is essentially saying, just because I just refreshed myself on it, what they're saying is this is a premature argument to be making, right? That
yes,
that emotional distress claims require sort of an independent factual analysis on a case by case basis, and it simply can't be resolved right now because they haven't even gotten any discovery. And
but Kate, yes, but here's the thing, right? So what they're saying, this is a very, very early motion. All right. So what the defense is saying, that even if we accept even if there's no discovery, there doesn't have to be discovery. And even if we accept that all of the facts you are alleging are true, there still wouldn't be a claim for emotional distress under the law. So that's basically what the defense is saying. Now, the plaintiffs are definitely going to say, well, this is something the jury should decide. This is something that shouldn't be decided by the judge alone, because, again, they're asking the judge to dismiss these claims. So so what you're saying is a standard response from the plaintiff. But, the judge may say to the plaintiff, well, even if all the facts are assumed to be true under the law, I can dismiss this as a matter of law.
And I just
Right.
want to welcome Matt from Boundless Millennial. I think he was probably waiting there for a few minutes, but I couldn't see you. Sorry about that, Matt, because I was looking at the document on the screen.
No problem. How's it going?
We're going good. We're going to law school here with Margaret. She's teaching us a class here.
Well, I used to teach. So I did teach at Boston College. I taught law at Boston College. And so I would have to teach. I taught a class. So all my classes would be on, different types of the law, like criminal and then all this. But I'd have to teach a big section on civil law and civil procedure and explaining to the students. We actually went through this type of preliminary motion. I would actually have, it was an exam question on one of my, many tests that I would give, but it's hard for people to separate the differences between criminal law and complaints versus civil law and complaints. But this is a motion that is, again, decided, like, if we accept all the facts to be true, there still isn't a cause of motion and they can be dismissed as a matter of law. So that's what it's about. And I remember it was kind of hard for some of my students to understand this concept, but, if they didn't understand it, they would get the question wrong on the exam.
So I had a choice to continue. I can go back to the document if you want, but I can only put one thing on the screen, and I wanted to show that we do still have it is now ready to go up live whenever they begin.
Yeah.
And
well, at least it gives us that's fine. At least it gives us a preview of what to expect from the motion hearing. So you should be hearing probably a lot of the same language,
Yeah.
And they're going to be addressing these particular areas of law, because the judge has already read the memorandums of law by both sides, and the judge will not make a decision today.
Oh, let me read this to you. This is the last part of it that we didn't get to, but I can just, it's only a paragraph, but this goes to what we were talking about. This is John's niece, Kaylee. So as far as Kaylee's claims for emotional distress, within count 13, Kaylee asserts multiple claims for emotional distress, but does not ascribe what conduct applies to what type of claim. In other words, negligent versus reckless versus intentional inflictions of emotional distress. The plaintiffs allege that the defendant spoke to a third person on a speakerphone in Kaylee's presence, waking her up in the process and notifying her that something may have happened to the decedent, inferring that Kaylee perceived John's death. So that goes to what we were talking about. The plaintiff also alleges that Karen feigned concern for the family and drove her SUV away from John's residence after John was declared dead. So that's different. And finally, the plaintiffs again allege that the defendant created a false narrative for the reasons previously stated and as set forth below. The complaint fails to state any cognizable claim for emotional distress upon which relief can be granted to Kaylee.
Yeah.
So that's all very interesting there, isn't it? From a legal standpoint.
It's kind of along the lines of what we were talking about, though.
Yeah.
So we'll see.
I mean,
okay.
The thing about today's hearing, unfortunately, I think, is that it's more of a PR stunt than it is anything else. And it really bothers me I anticipated that they would go down this road for sure. I think it's not shocking. It's not anything that was unanticipated. It's just so distasteful because now the opposition is not the Commonwealth, right? The Commonwealth has a lot of authority, a lot of power. They're nameless, faceless people. This is their job you know what I mean? It's an institution. Now the opposition is the victim's grieving family. And
Kate, this is standard. this is something that.
Oh, no. I know as far as the motion to dismiss.
Yeah,
those.
for the motion, it's not a PR stunt at all. I mean, even, you might, you got Jackson saying all this stuff, but even if like this was a wrongful death lawsuit that I did insurance defense work. So this is a motion I would bring. It's standard. It's like, oh,
Right.
so you have to look at it like I wouldn't be doing my job if I didn't bring this motion. So
No. I
yeah.
understand that. I didn't mean
Yeah.
the motion. I apologize.
But
I meant
there
no,
definitely,
it's okay.
Kate, I think Kate's right. There will be a big performative aspect of this,
Right.
as there always is with Alan Jackson.
yes,
the
yes.
announcements that they've
Of course.
made since, particularly I'm thinking through Howie Carr this morning, they're
Ugh.
announcing that they're going to announce everyone that they're suing, and this is the payback tour, and oh no, she can't sue Hank Brennan or Michael Morrissey, but the Mick Alberts better watch out. Like this.
No, that's ridiculous. That's ridiculous.
Right.
And I'm disappointed with Howie Carr because I've known Howie and I used to be on his show and everything back in the day, like when I was covering Whitey Bulger, and we both wrote books on Whitey and all that. We'd see him every day. I used to like the way he covered the mob and it was anti-FBI and all. I thought that was pretty cool. But man, I don't know what happened this time around. He just really went on a PR stunt. That's so crazy.
So Matt, what have you been up to? You still been covering the case on TikTok, or what you been up to?
A little bit. I mean, all the stuff that's out now, it's like, I don't know. I just feel like it's such nonsense, and people that are still like clinging on to it as if there was some big conspiracy are just complete morons. And it's like, I don't even want to listen to it. So I haven't been paying that much attention because I already know what the facts of the case are. So I just know there's a bunch of crap that like flows around online, and I'm just over it, kind of. It's like pathetic. It really is. Like all the people defending a drunk driver. It's disgusting.
Yeah.
We'll just stay tuned because they do have the camera feed going now. So they
And
probably
there's
should be
Jackson.
starting.
Jeez.
Yep.
What does he know about civil law? I bet he knows very little.
He's there, as he said on the Billy Bush show last week, to interrogate the witnesses. That's his role in this case.
Oh, I know, but it's like, come on.
And he invited people to. He said Billy Bush said, "Is this worth watching today?" And he said, "Tune in." So he's to Kate's point. It's all going to be performative, just like going back in the early March of and May of 2023 when they were doing that, and the Judge Canone even had to kind of warn him because he was angling his displays towards the cameras, and pretty full courthouse.
I know.
And there's the O'Keefe family.
Yeah, I feel so bad for the O'Keefe family. My God. Ugh.
Yeah, I mean, I don't think anything could be worse than something like this happening and then the whole public taking the side against you when
I
all
know.
you're trying to do is get justice. It's so gross.
It is. And, one thing I will point out, the change of venue. So the civil case was filed in Plymouth County, which thank God it's not in Norfolk County where the criminal trial was. So maybe we'll get a jury who can be a little fairer. There should have been a change of venue, in my opinion, for the criminal trial all along. Really. It shouldn't have been. I mean, we had a lot of jurors from Canton and, I don't know. So this will be a little bit better for the plaintiffs.
And of course, the rules on a jury are different in a civil case, right?
Oh yeah, I mean it's by so first of all, the standard of proof is preponderance of the evidence as opposed to beyond a reasonable doubt. But still, I prefer a jury from any other county than Norfolk. Sorry if you're from Norfolk.
Good afternoon, Your Honor. Good afternoon. All before the court is 2483 CV 692. This is the case of Paul O'Keefe and Alia versus C&C Hospitality, LLC, DBA, CF McCarthy. That Alia case is called for status and for Rule 12 motions. Counsel, please introduce yourself for the record, beginning with plaintiff's counsel. And if you could state the party you represent as well. Thank you.
Good afternoon, Your Honor. Attorney Mark Diller on behalf of the plaintiffs.
Good afternoon, Your Honor. Dan Buck on behalf of the plaintiffs. Okay, good afternoon.
Good afternoon. Good afternoon, Your Honor. Damon Seligson on behalf of the defendant, Karen Reed.
Okay, good afternoon.
Good afternoon, Your Honor. Charles Waters for defendant Karen Reed.
Good afternoon, Your Honor. Alan Jackson on behalf of Ms. Reed.
Good afternoon.
Good afternoon, Your Honor. Aaron Rosenberg also on behalf of Ms. Reed.
Good afternoon.
Good afternoon, Your Honor. William Keppel on behalf of Karen Reed.
Got it. Okay,
Good
good
afternoon,
afternoon.
Your Honor. Christopher George on behalf of the defendant Karen Reed.
Good afternoon, Your Honor. Marissa Palladini on behalf of Karen Reed.
Good afternoon.
Good afternoon, Your Honor. David Hassett on behalf of Waterfall Bar and Grill.
Okay. I'm sorry, did you say the waterfall?
Waterfall, yes, Your Honor.
Got it.
Good afternoon, Your Honor. Clint Gabrielli also on behalf of Waterfall Bar and Grill.
Good afternoon.
Good afternoon, Your Honor. Lincoln Rose on behalf of the defendant, CF McCarthy's.
Good afternoon. Okay, that's all the counselors. Good afternoon, folks, and welcome everyone to the event for this afternoon. When I was assigned this case last spring, the first thing I wanted to do was try to get a sense of where we all are going to fill in our tracking order and get a sense of what direction this case is going. And in the meantime, it looks like there was a motion to dismiss filed by the defendant. So what I would like to do is go through some of the procedural issues that you see in the case for now. We can talk about tracking order. I do think that it's important to get a trial date established at this point, like we would do with any kind of a wrongful death tort action. So to that end, we'll start with the plaintiff. What do you see as procedural issues? I'd like to get an update on discovery, on how that's all going. Counsel? And then we'll get into the motions to dismiss as a substantive issue. I know there's a lot of people here that want to see what the case is all about, but I think it's more important at least to get an idea procedurally where you stand.
Understood, Your Honor. Plaintiff has served all of the defendants with discovery. All of the defendants are currently late with regard to producing discovery. We have not received any as of yet, or minimal. We have started to get some of the documents from the DA's office, though we are is significantly deficient at this point. We're still waiting for the records to come in. So we undertook with the stay that we weren't able to get any information, and the DA's office wasn't turning anything over while the criminal matter was pending. So we're still trying to get all the documentation in.
Okay, but just if I can follow up on that, the stay that was issued, Judge White had issued one back in maybe the fall. I had issued one when the criminal trial was ongoing. That was sort of a self-defining 60-day or whichever comes first. So that should be pretty much in the rearview mirror for now, right?
I recognize that, Your Honor.
Right.
So when the stay was lifted, all discovery was served on the parties or thereabouts.
When you say discovery, we're talking about depositions, documents, notices of depositions or no?
Only one deposition has been noticed, and it's been tabled because we don't have any documents at this stage.
I see. So it's really the paper discovery that you're looking for. And when you say the DA's office, that obviously is not the defendants, that's going in a different direction, but you're pursuing that sort of on your own?
Right, but we've also, I anticipate that the defendants have all the same data that was exchanged during the criminal matter, to which we haven't ever received. So we have requested that both from the defendant, and we've requested it from the DA's office.
Okay.
It is coming in from the DA's office in parts, and I anticipate we should have it all within the next 21 days is my guess.
Okay. All right. Procedural issues from the defendants. We can start with you, Attorney Seligson.
Thank you, Your Honor. As we're anticipating the status of this case, it's important to inform the court that from Ms. Reed's perspective, we have affirmative claims that we intend to bring on her behalf. Those claims stem from the same facts that are at issue in this case. Those claims, Your Honor, are against parties that are not in the litigation at this point, including the Massachusetts State Police, Lieutenant Brian Tully in his personal capacity, Sergeant Yuri Buchanan in his personal capacity, Michael Proctor. Those claims would be in the nature of violations of Karen Reed's civil rights, In conspiracy, the claims against the Massachusetts State Police would be negligent training, supervision, and retention of Massachusetts State Police troopers. We also intend, Your Honor, to bring claims, affirmative claims, against Brian Albert, Nicole Albert, Matthew McCabe, Jennifer McCabe, and Brian Higgins, who were the occupants of 34 Fairview Road in Canton on the night in question. Those claims will be in the nature of civil conspiracy, violation of Karen Reed's civil rights, and then a claim against the town of Canton through its police department for negligent failure to secure the garage and the sally port. We asking the court's permission to bring those claims in this case because they do arise out of the same nucleus of operative facts. In order for us to fairly defend Ms. Reed in this case, those claims, those parties need to be asserted in this case. What we'd like to ask the court's indulgence for is we have a proposal of how to bring those claims in, given the voluminous nature of this case. That would be 10 additional parties coming in. To do that, we would be alleging that the individuals in the House diverted attention away from themselves towards Ms. Reed, that law enforcement then acting on that diverted attention away from her, because the people in the House were either police or police adjacent who were socially and personally connected. Then they collectively conspired to ensure that what happened in the House was not explored and investigated. And instead, Ms. Reed was wrongfully targeted, maliciously prosecuted, made to face 2 criminal trials for the death of John O'Keefe, and is now facing allegations of wrongful death, all stemming from the same claims. How do we synthesize the process to bring these claims and parties in? What we're asking the court to consider is for us, at the time we file her answer to the complaint, we've got some claims that we're asking to be dismissed, regardless of how the court decides those. We still have to file an answer on her behalf. Our suggestion would be to file those claims against those parties in the same pleading. Serve all of those new parties with that complaint. Allow them 30 days, not the normal 20 days, to respond so the court can have one hearing on whether some may bring dispositive motions, some may file general answers, so that we can then decide how and who is in the case and proceed forward. So I bring that to the court's attention. And I'm happy to brief it so that Mr. Dillard can have an opportunity.
Well, at a minimum, you're going to do that. I'm envisioning what the plaintiffs are going to say to this rather extraordinary process, but go ahead.
But that would be, otherwise it's going to be a very unwieldy, delay-inducing process, and we're not looking to do that. This accounts for trying to conserve judicial resources, trying to have a streamlined approach, at the same time making sure that all the claims and all the parties are in this case. The alternative would be for us to file a separate action on Ms. Reed's behalf, alleging these claims, and then move to consolidate immediately with this case, which Your Honor has broad discretion to allow. The point being, the claim should be in this case. They all arrive out of the same facts. They're not separate. And that's essentially what we'd like to do. We'd like to brief that, Your Honor, and have the plaintiffs respond and then proceed from there.
Okay. All right. Let's hear it then from the Waterfall.
Yes, Your Honor. We are in the process of completing written discovery propounded to us from the plaintiff for under extension until next month. We anticipate that will be completed then. We as well.
When you say an extension, this is an agreed to extension? Agreed. Because the tracking order is what it is. We'll get to that in a little bit.
It's been agreed to, Your Honor.
Okay.
And then, Your Honor, we're looking at depositions, but we don't want to consider noticing depositions yet until a lot of the document requests have been answered in the subpoenas for keeper of records. We haven't seen any of the records. We're aware of them certainly from the criminal trial, but when there are a lot of records, as I understand it, that are still to be produced, so that we would then proceed with depositions as warranted in conjunction with council and obviously picking dates that work for all. But that's what we foresee in the immediate future, Your Honor.
All right, thank you. Let's hear from C.F. McCarthy, then.
Your Honor, in a similar vote as to Waterfall, we were putting finishing touches on our discovery responses. The last leg of it is just direct communications from employees in that instance, some of whom no longer work with C.F. McCarthy's, but we anticipate having that completed in the very short term and getting that over to my brothers.
Okay. All right, thank you. Let's hear from the plaintiffs then, in terms of response to the procedural issue that was raised, in particular by Ms. Reed's counsel. Are you aware of the circumstances that they're seeking to join 10 additional defendants into this action?
Absolutely not, Your
It's the
Honor.
first notice you've gotten?
Of course, I would
Not how the
expect
court
that.
system likes this stuff to work, folks.
Right, I would expect the courtesy of a meet and confer, or at least let me know. Obviously, they can choose not to do so. That's their prerogative, but I certainly would have liked to have been made aware. Section 1983 actions, I believe, Your Honor, would have to go up through the federal court. We're not seeking to have this case removed in the federal court. We started it in the state court. We're intending to move forward in the state court. We would like to have a state court, Plymouth jury decide this case. So to the extent that my brothers and sisters and all of those who are involved believe that they have other legal rights and they want to pursue other legal theories, that's their prerogative to do so. When it comes to interfering with our opportunity and right to justice, we're not looking to sideline that, Your Honor.
All right, any response, counsel?
Thank you, Your Honor. We are asking for permission to serve a motion to advance this procedural proposal. So Mr. Diller is not being surprised by the argument that we're going to present to the court. He will have an opportunity to respond. There's no requirement that civil rights claims be brought in federal court. In fact, this court has jurisdiction over those claims. They all stem from the same facts, Your Honor. In the plaintiff's complaint, there are allegations that we need those parties to defend against. This is not just a wrongful death action. Our narrative of what took
But it
place.
is, though. It's the plaintiffs. Well, just hear me out for a second. And when you say that it's not just a wrongful death, that's what the plaintiffs have alleged. The defendants have filed motions to dismiss portions of those. So this, at its essence, is a wrongful death action being brought by the plaintiffs, right? So what you're seeking to do is to be allowed to amend these proceedings and to effectively bring in 10 other defendants for the claims that the defendants have against those third parties that aren't noticed here, right? So you've got to procedurally give them notice as well as the plaintiffs notice of this event before it goes to any adjudication by the court.
And that's what we've built into this proposal, which is trying to streamline that process, not depriving them, the new parties, of the opportunity to argue both the procedure as well as the substance. And we're suggesting, instead of serving party X with a third party motion for a complaint, then that party opposes it, then the court rules, then that party perhaps is brought into the case and then brings another motion to dismiss substantively. We're not seeking to.
Isn't that what the rule requires?
The rule does require that, but the court has discretion to consider the streamlined approach. And we'd like to brief that for Your Honor, but we're raising it at the status conference so that because we are scheduling deadlines and events out into the future, we'd like to at least have the opportunity to advance that argument for the court and allow Mr. Diller to respond to it. And then we will act accordingly. That's the purpose of the disclosure of this today, Your Honor.
All right, so I don't know that there's any ruling by the court today that would have to be made relative to that because it isn't even filed yet, so that there's nothing before the court. So ideally, what my instructions to the clerk's office by setting this event up was to get a trial date from you folks and then work backwards like we would do with any wrongful death tort action, which this case is. I take exception to the defendant's notion that this is not just a tort action. It is. That's what it is. It's a civil case. I know there's a lot of people who are interested in this case, but at its heart, there are at this time eight parties involved in this case, correct?
Yes,
There's 5 for the plaintiff and there's 3 for the defendants, 2 corporations and Ms. Reed. So that's the way the case is shaping up. You've got your tracking order, so you understand what the deadlines are now. I have the tracking order, I think basically shows this case as having discovery. Yeah, your discovery is supposed to close August of next year. Your Rule 56 motions to be done by October-ish of next year. Final pretrial conference February of 2027 with judgment by August 26th of 2027. So that's what the tracking order has in store as the case stands now, right? I mean, we could get you a trial date way sooner than that if you wanted to. I mean, literally, I could, the clerk and I were talking earlier before today's proceeding, and I may end up having to suspend, depending on what the circumstances. We were charging the jury on a homicide case earlier today. So we have a deliberating jury right now, so I don't know that I may have to suspend and then rejoin here in a little bit. But for now, so you understand it, we could get you a trial date as soon as practically this spring on this case, but to join 10 new defendants under wholly separate theories for people that haven't even been joined yet in this litigation puts that on its head. There's no way you wouldn't even have this procedural process outlined by the spring, most likely.
I understand that, and that's the dilemma that we're trying to bring to the court's attention, because there is going to be an affirmative.
Well, you're saying affirmative. You said earlier affirmative defense in this case, which those would not be affirmative defenses. Those are wholly separate third-party causes of action against people who are not part of this litigation, correct? So it's not an affirmative defense.
It's not an affirmative defense in the traditional sense, but it is part of the defense in the face of the wrongful death claims. The wrongful death claims stem from the same facts that the affirmative claims would be seeking to be pursued against. So it is the same set of facts. If we were to file a separate action, Your Honor, where Karen Reed is the plaintiff and these parties that I've identified are the defendants, we would be pursuing down 2 separate pieces of behemoth litigation when we can consolidate them at the same time. That's what we're trying to suggest may be a more streamlined approach. And it's not intended to delay. It's actually intended to try and synthesize the process and conserve resources, attain judicial economy without prejudicing the plaintiff. Discovery is already ongoing, but to have 2 depositions, for example, of parties in 2 separate cases, where we can have one and the claims could proceed at the same time, just seems to make judicial sense. That's why we're raising it. But we'd like to brief it if the court gives us that permission.
Okay. All right. On that last discrete issue, anything else from the plaintiffs?
We have served them with discovery, asking them, they have a burden if they're going to do affirmative defenses to establish that there are third parties who are responsible here. That can be their affirmative defense, but they have a burden to prove that. And if they can't meet that burden, then it should never come into our case. If they're seeking to overlap these 2 cases and throw it as far wide ranging as they just announced, then there's no way that we would not be prejudiced by their strategy in the plaintiff's underlying case.
All right, those issues are reserved. I certainly am not going to make any ruling on that. There's nothing formally before the court, no written motion, no Rule 9A or 9C certificate, none of that stuff. So it's not procedurally before the court, but certainly I appreciate hearing the argument nonetheless that this may be the future landscape of the case. What also brings us here, when I noticed the status conference for today, the defendants have filed motions to dismiss. If you're prepared, I'll go forward on that, let you deal with the substance of the motions to dismiss. I have read through your material, so I get the gist of what the defendants are raising. Counsel, would you like to proceed?
Thank you, Your Honor. As we've briefed, Your Honor, the counts that are at issue in the motion to dismiss are counts 13, excuse me, the counts 10 through 13. They are infliction of emotional distress claims. As we have presented in our papers, none of the plaintiffs observed the alleged incident that is described in the complaint. None of the plaintiffs came upon the decedent in close enough proximity to state a claim for emotional distress. There is no, the cases, Your Honor, limit when a claimant can claim emotional distress. The cases talk about temporal, spatial, and relational limitations. Taking the claim that Kaylee Furbush has alleged, that claim is for negligence / reckless / intentional infliction of emotional distress. And the basis of that claim is that there was a discussion on the telephone or discussion after Karen Reed had left 34 Fairview in Canton and had somehow started to fabricate a story about what had taken place. Kaylee Furbush was not at the scene, and the perception of someone dying is not an actionable claim under any case that we can find in Massachusetts state law. So she wasn't at the scene, didn't come upon the decedent, and therefore doesn't have the same types of proof, at least is played in the complaint, that would satisfy the limitations that the case law sets out, the temporal, the spatial, and the relational. With respect to the claims of emotional distress that have been brought by John O'Keefe's mother, father, and brother, again, they were not witnesses to the event. They came upon him many hours later. There are cases, and particularly the Cohen case that is cited in our brief, that speaks to the time that passes between an alleged event and when a family member or a bystander witnesses the consequences of that alleged event. And in that Cohen case, the court speaks to the fact that the mother of a young man that died in a plane crash didn't get to find out about it until many, many, many hours later, and the court denied the right to pursue an emotional distress claim. More importantly, Your Honor, there is a remedy here. If for the sake of argument, there is a remedy here through the wrongful death statute. And the wrongful death statute compensates for the types of harms that are alleged in the complaint. So what we're asking the court to do is to dismiss out the emotional distress claims because they are duplicative and allow the plaintiffs to pursue the wrongful death action singularly. We rest on our papers. Thank you, Judge.
All right, thank you. So let's turn to the other defendants if they want to be heard. You've filed separate motions essentially arguing the same relief, but if you have anything you want to add, you certainly can. The Waterfall?
Yes, Your Honor. On behalf of Waterfall, just very briefly, I think the distinction here that counsel's making is that these claims, these infliction of emotional distress claims are intended when you're in the zone of danger or you're a recipient witness. And in this instance, it's many, many hours later that the parents are seeing the decedent in the hospital. I think it's after 7:50 a.m. And so based on what the Cohen case states and in terms of the principles that the courts have applied here, it just isn't from a relational standpoint close enough in proximity to be able to advance this type of claim. And in terms of the wrongful death statute, those loss of consortium damages, the damages of the loss of the son, if the plaintiff is making this claim going forward, are in fact addressed in that statute and obviously would be available as remedies to the plaintiff.
What about Semino versus Milford Keg Incorporated? I have a 1982 case that I found talking about the wrongful death, emotional distress injuries. Have you reviewed that case? I'll give this case site, 385 Mass 323. It's a 1982 case. So it would seem to suggest that that emotional distress is really not preempted by the wrongful death statute.
Your Honor, I think the wrongful death statute alone would not necessarily cover all of the damages, but my argument would be more in line with the argument that in terms of where they are in relationship to the accident, since it wasn't witnessed, and since it wasn't immediately thereafter that they came upon the scene, in a roadway, in a driveway, and observed the decedent, I would argue, Your Honor, based on that, that that's a problem for the plaintiff moving forward, and that would be the court's consideration. I appreciate, Your Honor, that there are some differences in the wrongful death statute and emotional distress claims.
Okay, thank you. Ferreter versus Daniel O'Connell Sons, a case that goes back to 1980, also kind of speaks to that issue too. Let's hear from C.F. McCarthy's on that. Anything else to add on the motions to dismiss? No. Okay. All right, great. All right, I'll take that issue under advisement. I do have some, I'll read through your briefs a little more closely.
Allow us to.
Yeah, of course. What I was going to say is that what will happen in just a few moments, I'm going to give the plaintiff an opportunity to respond to that. But I want everyone who's sitting here to understand that the comments I'm making now are not really doing other than just trying to tease out what the issues are. Motions to dismiss are not based upon the evidence, but rather on the allegations that are contained in the complaint. And those allegations, for purposes of a motion to dismiss, have to be accepted as true. And the question is whether or not the plaintiffs have stated a plausible claim under the case law, Iachino and others that deal with this issue. So with that context, plaintiff, if you want to respond to both the motions to dismiss raised by, I should say, both the two corporate defendants and Ms. Reed.
Your Honor. Thank you. The question that's really posed for this court is, like you just said, assuming all facts are true, indulging every inference in the plaintiff's favor, does the plaintiff's complaint plausibly suggest that plaintiffs are entitled to relief? The answer is yes. This is a motion to dismiss. The lowest standard, the Brum case, plaintiff's obstacle is a minimal hurdle, a relatively light burden, so long as the court looks at the allegations holistically. If relief to the plaintiff is plausible by the cumulative effect of all the factual allegations pled, we survive the motion to dismiss standard and we move forward to discovery like we should in all cases and in this one. There are three arguments that my brothers have put forward in this case. We oppose all three of them as follows. Number one, the defendants incorrectly state the law by suggesting that NIED claims are subsumed or preempted by the wrongful death statute. Number two, Your Honor, the defendants improperly seek to limit the scope of NIED claims by creating an arbitrary bright line test for such cases. Number three, Your Honor, the defendants failed to holistically consider the facts alleged and the known vulnerabilities of the plaintiffs when evaluating the defendant's extreme and outrageous conduct in violation of the infliction of emotional distress standard. I recognize that this court is not new to this case, and I recognize that most people already understand the facts, but I think it is important and significant that I at least highlight the ones that will be at issue here today. Throughout, we intend, like we did in the complaint, to refer to John O'Keefe as JJ. That is what he was affectionately referred to by his niece and nephew. JJ no longer has a voice. His life was wrongfully taken on January 29th, 2022. He lived a life of service. He was a Boston police officer, and his personal life, when JJ's older sister and brother-in-law tragically passed 2 months apart from each other, leaving two young children orphaned, JJ stepped up. He agreed to parent those children, to raise them as his own, and to support them. Fast forward to 2022, Your Honor, JJ is involved in a relationship with Miss Reed. It's been going on for a period of time at that time. January 29th, 2022, Karen drives drunk. She reverses her SUV. She knocks JJ down. She leaves him to die in the cold. And Reed knows that she strikes the plaintiff. Rather than seeking to help or calling 911, she returns to JJ's home. There, JJ's 14-year-old niece, Kaylee, a plaintiff in this case, is home alone, asleep. That's when Karen starts plotting. Now, it is significant for the facts for you to understand the context here. Karen Reed knows Kaylee well. She's been in her life for almost up to 2 years. She has served as a part-time maternal figure in her life. She knows that Kaylee is a vulnerable child, having lost 2 parents tragically. And 1 to 2 hours before JJ's body is ever found, before anybody knows his whereabouts, Karen Reed decides to wake up Kaylee in a panic. She tells Kaylee something happened to JJ. He's dead. He's been hit by a plow. Did I hit him? All to a 14-year-old child woken up from sleep who's already lost 2 parents. After provoking this chaos in the middle of the night, Miss Reed leaves Kaylee alone, vulnerable, shocked, and afraid. It's now 1 to 2 hours later. It's at or around 6 a.m. in the morning. JJ's injured body is now found. Right where Karen left him, buried in the snow, 911 is called. Now is when JJ's family learns of JJ's injury. JJ's injuries at this point enter into the O'Keefe's consciousness. At around 6 a.m., they rush to the hospital. It's 7:50 a.m. That's when the hospital pronounces JJ dead. And within minutes of being pronounced dead, that's when the O'Keefe family sees their son in the injured state that he was in as a result of the wrongful conduct. From January 29th forward, Your Honor, Karen Reed plots, she fabricates a conspiracy, she launches a public campaign of disinformation, and she involves a blogger named Turtle Boy. She leaks not for public information through him. She pits her followers against the O'Keefe family, and all the while, Karen knows that the O'Keefe family is also vulnerable, grieving another tragedy in their family. The O'Keefes and Kaylee suffer severe emotional distress. It's more than anguish and more than grief, and it is not overlapping with the wrongful death statute. So the first argument that the defendants made, they claim that JJ's parents are precluded from bringing NIED claims because such damages are duplicative of the wrongful death statute. We reject that argument. JJ's parents are the next of kin, and their emotional distress claims are not preempted by the wrongful death statute. They took their first shot across the bow by making that their primary argument. Presumptively, they did so because it believed it's their best argument. But the problem with that argument, as Your Honor has already pointed out, it patently misstates Massachusetts law. You have pointed out the Cimino case, where, let me just point out first the wrongful death statute. It has 2 components for damages. It has 2 buckets of damages. It has the estate's damages. Those all are JJ's damages, his conscious pain and suffering, the medical bills, things that relate to his damages. And then we have the second bucket, the next of kin bucket. Those are lost value damages. The lost value of JJ being in his next of kin's life. And in that case, Your Honor, it is just the parents. Now, they suggest that those are overlapping with the NIED, but Your Honor was right to point out the Cimino case, where a drunk driver kills a 9-year-old boy. The father of that 9-year-old boy brings a case against the drunk and the bar for over-serving him. The father brings 2 separate causes of action, one for wrongful death, one for NIED, negligent infliction of emotional distress. The court held in that, and I quote, argument that plaintiff's claim for emotional distress is preempted by wrongful death action misconstrues the common law cause of action for emotional distress. Emotional distress, as the concept has evolved in the Commonwealth, is a severe psychological shock directly resulting from experiencing or witnessing the effects of the defendant's conduct. A claim for damages based on emotional distress, the court says, does not include an administrator's claim for loss of consortium, which will be present in every wrongful death action such as this. Since emotional distress is a wrong to plaintiff distinct from what was done to his son and the statutory beneficiaries of the decedent, it is not a duplicative remedy. It is not preempted by the wrongful death statute. And that's page 334 of the Cimino case, Your Honor. Cimino still remains good law. You were right to point that out. It directly contradicts everything that my brothers just argued here in this court. And I see no reason why this court should overturn the good standing law that exists under the Cimino. We ask that Your Honor deny the motion to dismiss for that first argument. The second argument that they make, Your Honor, is that the plaintiff's NIED claims are not sufficiently contemporaneous with the alleged accident because the family sees JJ 7 hours after the accident. But the law does not endorse such a narrow, arbitrary interpretation of the law. It is misplaced for the defendants to focus arbitrarily on the time of the accident, because let's look at the law itself. The liability for NIED depends on number of factors: where, when, and how the injury enters into the consciousness of the plaintiffs. And it also requires the degree of relationship between those plaintiffs. But I repeat, where, when, and how the injury enters into their consciousness. It is misplaced for the defendants to suggest that it matters that plaintiffs were not at the scene of the accident. Because as you pointed out, the Farrader case stands in the exact opposite, where the plaintiff who rushes onto the scene and finds his loved ones injured has no greater entitlement to emotional distress for that shock than a plaintiff who rushes to the hospital, so long as the shock follows closely on the heels of. It is misplaced for the defendants also to suggest that there is a bright line test for the number of hours that passes between the time of an accident and when the injury enters into the consciousness of the plaintiffs. Your Honor has persuasive authority from the Zachary case that shows that an NIED case can survive even when the close family doesn't see the deceased body or the injured body until a day later after the wrongdoing. There is no bright line test. NIED is a fact-intensive analysis. And when we apply the law to the facts of this case, let's look at where, when, and how the injury enters into the consciousness of the people that we're bringing those cases for. It's 12:30 a.m. and nobody except Karen Reed knows about JJ's injuries. Defendant's wrongdoing continues into those early hours. She knows she struck him. She seeks no medical help. Instead, she chooses to cover it up and hides the injuries from anyone. It's not until 6 a.m. that JJ's injuries are even capable of getting into anyone's consciousness. The O'Keefe family immediately learns of JJ's injury, and they closely on the heels, they rush to the hospital, at which time they see the deceased body within minutes of him being declared dead. It is incredulous to think that a wrongdoer who hides the wrongdoing and the injury from anybody can be relieved of liability simply because the injury becomes knowable only after they disclose it. The defendant's cited cases are inapposite. They have no relationship to what is being asked of this court. They all involve a motion for summary judgment standard, which is a very different standard than the one that we are talking about here today, the motion to dismiss, the lowest hurdle to overcome. They try to equate it to a mother who learns of the rape of her daughter 7 months later, but that rape was known to other people within days. They try to relate it to the Migliore case, which has no relevance because it deals with somebody who has no close relationship. They didn't even know the decedent, and therefore it doesn't meet that standard. And then they rely on the Cohen case, which I heard both sides try to suggest has relevance. But in that case, Your Honor, the mother learns of her son's death 7 hours after the death. That's 7 hours after the injury occurred. And by the way, it was already knowable 7 hours earlier by other people when that plane crash was projected, and the son of the woman who brought the claim knew about her own, his brother's death. The mother is 1,000 miles away, so spatial proximity is not there, and she only learns of it via phone. Does not experience the injury and never sees the body. Contrast that with everything that we talked about, Your Honor, where as soon as it was knowable, they learned about it, they rushed to the hospital, they saw the body, and they saw the body within minutes of him being declared dead. The purpose of the law is to distinguish between emotional distress from perceiving an injury versus the expected anguish that any person would feel from the death of a loved one. I want to talk briefly about Kaylee and her NIED claim to suggest because she wasn't at the scene or because she was not at the hospital that day and they tried to spare her of that does not suggest she doesn't have a right. In fact, she experiences the trauma, the panic, the chaos of the injury contemporaneous with Karen Reed waking her up in the middle of the night and exclaiming that her parental figure, the third that she has now lost, was dead, hit by a plow or her SUV. Notably, this enters into her consciousness before anyone other than the wrongdoer knows of the injury. To the extent that defendant seeks relief because Kaylee did not see with her own 2 eyes, I refer you also to the Cohen case, which they cite for different reasons, but in it, the language talks about sensory perceptions to suggest that you can't use other senses in order to perceive and experience the injury or the injurious event is wrong. Otherwise, no blind person would have a legal right under NIED. We have many senses. We use them all the time. And when it enters into our consciousness, it's hard to undo of it. It is very different from learning that your close family member has died. That is upsetting. It will be upsetting to anybody. But to have experienced the event or the injury and enters into your consciousness, that is the very reason and the foundation why NIED exists as a claim. So on that second, we also suggest that you should deny it because they experience the injuries closely on the heels of them being knowable and perceivable to anybody. Third, Your Honor, the defendants argue that the intentional/reckless infliction of emotional distress claim should fail because there's no extreme or outrageous conduct directed towards the plaintiff. But when viewed holistically, the facts demonstrate that Ms. Reed should have known her extreme and outrageous conduct would be detrimental to these vulnerable plaintiffs. And I use the word vulnerable plaintiffs because it's relevant to our case law, Your Honor. It's misplaced to suggest that the conduct needs to be directed immediately towards those plaintiffs. As long as she should have known that the emotional distress was the likely result of her conduct, that's sufficient under the reckless infliction of emotional distress standard. So how do we evaluate what is extreme and outrageous? It's fact intensive, but the law does recognize that some critically important factors that need to be considered when evaluating what is extreme and outrageous. Plaintiff's susceptibility, defendant's knowledge of that susceptibility, and the relationship between defendant and plaintiff. The case law all suggests that that gives rise to extreme and outrageous conduct. In evaluating whether defendant's conduct was extreme and outrageous, the courts should consider whether individuals at whom conduct is directed is known to be particularly susceptible to infliction of emotional distress. Boyle versus Wenck, 1979 case we cited to, Your Honor. Our case law has recognized susceptibilities to evaluate extreme and outrageous conduct to be a recent hospitalization in the Boyle case, a cancer patient in the Harrison case, elderly or frail people in the Bailey case, or children, minors, based on their age in the Sarkonis case, all that we've cited to, Your Honor, and I'm happy to give you cites. The law in Roman versus Trustees of Tufts College says, as it relates to this, the court should put as harsh a face on the defendant's actions as the basic facts would reasonably allow. The relationship of a plaintiff to the defendant and her knowledge of the plaintiff's sensitivities is an important consideration in determining whether the challenge conduct satisfies the extreme and outrageous conduct. That's the Russell case. Let's talk about Kaylee as it relates to the infliction of emotional distress. Should defendant Karen Reed have known that emotional distress was the likely result of her conduct? Was defendant's conduct extreme and outrageous? Those are the questions that ultimately we pose to a jury. Kaylee was young, 14 years old. The defendant had a relationship with her, knew she was emotionally fragile, knew she was orphaned at the age of 6, knew that she lost both parents tragically. The defendant assumed this pseudo-parental role with Kaylee for nearly up to 2 years. The defendant, Miss Reed, knows that she knocked JJ down. It's in the middle of the night. She wakes up Kaylee abruptly. She talks about JJ being dead, being struck by a plow, being struck by a vehicle. Mind you, this is all hours before anybody has even discovered his body, and she is now actively talking about him being dead. Then, after creating this chaotic, upsetting situation in this young, fragile girl's psyche, she leaves her. She leaves her home alone, shocked and frightened. Compound that by defendant's choice to speak her false narrative publicly, to use social media, to leak public information through Turtle Boy, to control that narrative. Why is Turtle Boy out there saying the O'Keefe's family period of grief has expired and they are now fair game? Who leaked the autopsy photos that got published by Turtle Boy for this vulnerable family to have to be exposed to that they weren't seeing before? To the extent that the defendant argues that this is not extreme and outrageous, remember the law. It is the jury's role to decide whether the defendant's conduct was rude and clumsy or extreme and outrageous. That comes right from the case law. As it relates to the family, Your Honor, should the defendant, Karen Reed, have known that emotional distress was the likely result of her conduct? Was defendant's conduct extreme and outrageous? Again, those are the questions posed for a jury ultimately. But the law says conduct which the actor should have known would result in distress is actionable. And the plausibility standard, the motion to dismiss standard, which is where we're at right now, Your Honor, simply calls for enough facts to raise a reasonable expectation that discovery will reveal evidence of the illegal conduct. Margaret and John have now buried 2 children. Paul has buried all his siblings. Defendant always knew this. She has always known their vulnerability. And yet she creates a calculated and malicious campaign of disinformation designed to hide the truth in this case. She pits the O'Keefe family versus the Reed family, and a reporter who she asserts editorial control publicly proclaims to Reed supporters, the O'Keefe family's period of grief has expired and they are now fair game. Discovery will track how much leaked information defendants should have known would result in distress to the O'Keefe family. To the extent that the defendants suggest that this case fits nicely within any other case decided on this issue, remember the facts and circumstances here are exceptional. We wouldn't have these TV cameras or a full courthouse if they weren't exceptional. That is why we are here, Your Honor. It doesn't fit within a nice box like every one of those cases I cite. The Pillay case where we talked about false police reports and harassment petitions were not considered towards emotional distress because they were petitioning activity. I want to talk about that briefly because what Ms. Reed has done is not petitioning activity. It is not asserting a defense within a courthouse or having her legal counsel assert that defense or testifying at a court hearing. Instead, what Karen Reed is doing is not petitioning at all. She is waiving her Fifth Amendment privilege. She's speaking anywhere and everywhere that would give her a friendly audience with editorial control. She's gone on Dateline, Nightline, 2020, Fox 25, Boston Magazine, Vanity Fair, WEEI, Turtle Boy, HBO Max, ID Discovery, etc. There are more. This is an exceptional case that requires exceptional discovery, that requires us to decide this matter by a jury, not by a motion to dismiss phase, Your Honor. It is not like the Quinn case that they cite where there's an open adulterer involved, and so they think that's not extreme and outrageous. And it's not extreme and outrageous like it has nothing to do with the employment case where they fired somebody who had a criminal case pending, then they brought them back on, and he didn't like the way that they treated him after he was found not guilty, which is different, by the way, than innocent. The court should deny the third of those arguments. They should know that plaintiff's susceptibility and vulnerability are at issue in this case and are the very reason and foundation why it is extreme and outrageous conduct, and that defendants' improper actions would cause severe emotional distress. Defendants' actions were not rude and clumsy. They were extreme and outrageous. We ask Your Honor to allow this case to go forward with discovery, allow us to explore each and every one of those issues, because these are real damages for real people who have suffered long enough. Thank you.
All right, thank you. Any response from the defense?
Your Honor, briefly. Firstly, those allegations contained in the complaint are allegations which we will refute. Counsel cites to the Camino case, relies heavily on it. What counsel didn't tell the court is that in the Camino case, the father of the child who died in the car accident was himself hit. Part of the car accident, gets up, runs to see his son. It's contemporaneous, it's at the time of the event, and the court didn't have the same spatial, relational, and temporal concerns that the cases speak to with respect to emotional distress claims. So I point that out for the Your Honor. He also mentioned much about conspiracy theories, much about going out in the public and creating a narrative, which is precisely the reason why we're going to brief the issue about why those other parties need to be in this case. As I'd said, it is more than just a wrongful death action, Your Honor. I respect the opportunity to brief that, and we rely on our papers and defer to the court on the motion to dismiss.
All right, thank you. Any other defendants wish to be heard on the issue? Anything else? All right, thank you. Certainly, there's a lot to the complaint. And again, for the record, so that people understand this, this is a pre-discovery form of relief that the defendants have sought by way of dismissing certain of the counts that are in this complaint. And the court has to consider the allegations as being truthful and every reasonable inference to be drawn in support of that. So I will look forward to reviewing that. I'll issue a decision as soon as I can. As expected, the lawyers in this case have advocated the positions of their clients very clearly, and I expect that with the procedural things that might be asked for at some point, that this case will have a very long and tail to it as it goes through the litigation process. We expect that in the court system, we give people their ability to try cases and get a jury to listen to the arguments and to ultimately make a decision. My experience in doing this for a very long time in different contexts is that doesn't oftentimes bring the relief that people think it does. And so as a result, there's appellate processes. And so what I envisioned for the parties, unfortunately in this case, is a very long and sort of complex process that litigation provides. And you know, this is a civil case. It's not a criminal case. There are 8 parties as I identified, and those are the people that the court will be concerned with getting a fair trial at some point down the road. As I said, I could do this case, I could do this trial this spring if you'd like to. My sense is that there's nobody that's going to be ready to go to trial by the springtime. If you want me to sign a trial date, we could do so. I mean, literally, I've talked to the clerk, we could do it in March or April if you'd like to. But with the motions that are going to be pending, I suspect that that's not going to be the case, that you'll have to look at this from a more pragmatic point of view and decide when you're going to try to get this thing to a jury. You have a lot of work to do between then and now. I'd like to still get a trial date for you. Now, I don't know what that's going to mean in terms of bringing in other parties. You know, I didn't expect, because the court has had no notice, that there'd be this interest in trying to move this complaint in the direction of other parties who aren't even named in this lawsuit, 10 additional parties. And there's relatively novel theories as I'm hearing it, but nonetheless, we'll let the parties file the motions that they need to, and we'll address them as each comes. But my point in raising this all is that the parties also have another way to do this case. They can do it by way of potential resolution. And I mean this sincerely when I say that being a judge for many years, you learn things. What you learn is that oftentimes litigation is an inartful way to try to resolve parties' disputes. There's alternative dispute resolution, there's mediation, there's all kinds of other avenues that we advance to try to get people what they want, which is resolution of a case. The most important thing, it would seem to me, to any party to this case, is to resolve the uncertainty, right? Uncertainty is what you don't get when you go through the litigation process. You go through and you hope for the best. Lawyers work really hard for their clients, and we expect them to do that. Ultimately, the court system can make sure that the trial is done, and it's done in a way that's fairest that we can make it. And ultimately, a decision is made. Civil cases, though, are very unlike criminal cases, and that's usually not the end. Ask any of the lawyers here. Clients can ask your lawyers about post-disposition or post-verdict process. It can be really long and arduous. I've had the pleasure of having trials that are 16, 18, 20 years old, and they're still going. Your clients don't have to do that. The clients can try to put some efforts, at least as much effort in the litigation process as trying to resolve it. Why do I say that? Because resolving cases resolves uncertainty, which is perhaps the most important thing any client can get in a case. I say that because you'll have that opportunity through all the process. You've heard me outline it. Your discovery isn't even closing until the discovery is going to close next December, but it's really 2027 that you're looking for a trial in this case, realistically. Again, we could do it in 2026 in the spring if you want to. And I'm going to ask the parties to work collaboratively to try to come up with a trial date that is workable. I understand that's a wrench has been thrown into the works because of this other process. We'll probably have to deal with that in the short term. I'll pledge to try to get you what you can as quickly as I can. I tend to get decisions out pretty quickly. I tend to try to move things to get parties what they want, which is ultimately their day in court. I'm just telling you at the outset that I think that it's worthy of exploring possible resolutions on your own. You can do it through this court. We have a mediation process that you can avail yourselves of, judicial settlement conferences. You can go through private neutrals, because there are now 8 parties involved in this case, 2 of which are corporate defendants, 1 of which is Ms. Reed. And so that's going to give you a lot of opportunity for dialogue. My sense is I'm probably wasting my time by doing it at this stage of the process, but I think it's important that your clients know that there is an alternative way out of this. Money damages are all the plaintiff can ask for. Nobody can restore, we say this when people lose loved ones or that they have some meaningful part of their body or mind that's been lost in a litigation. We can't restore that. We award money damages. And so ultimately that's what the imperfect litigation system will have. Knowing that, there's a huge opportunity to try to resolve a case like this. And I would urge the parties to have very frank discussions with their lawyers about that and ask yourselves, is it worth going forward with all the uncertainty? And I'm not going to explore with your clients what everybody has to lose. Everyone knows that. If I were representing a plaintiff in this case, I would tell them all about things like the time it takes to get to litigation, how what we have the burden of proof. Yes, it's easier with a burden of proof that's by a more likely than not standard versus a proof beyond a reasonable doubt, but still it's a burden of proof nonetheless. But there's a time value of money. People don't, getting this behind them is an important issue. From the defendant's point of view, again, time is money. There's a lot of time, effort, and anxiety that is put together with a litigation like this. We have 2 ongoing, as far as I understand, the 2 businesses in Canton are ongoing, and they have their business decisions they have to make. Ultimately, they're defendants in this case. They have to understand the risk of going forward in a trial versus resolution. Of course, Ms. Reed herself, a lifetime of potentially facing the uncertainty of a judgment and what that will mean in terms of ability to put this matter behind and going forward. It's going to be very complex. So you can resolve that by looking at putting some effort into this case to resolve it. If you can, great. If not, we stand here committed to giving you the next opportunity to get it before a jury, which I'm suggesting to you you could do as soon as this spring if you want to. Okay. Anything else we need to address this afternoon?
Not from the defendant, Your Honor.
Okay, great. I'll issue a decision on the motion to dismiss. Tracking order stays in place as it is now, but here's my concern, folks. With this motion that the defense team is talking about putting together, I think that needs to be looked at sooner rather than later. It's a big deal, right?
Yes, Your Honor.
Okay. Why don't we get a status date? When do you want to, and we can do by Zoom, folks, if it's just as easy. My order was to have everybody here so that you all get a chance to meet. I want people to be understanding that this is a civil matter, and I want you to be, at least to some extent, trying to be civil about how to resolve your issues. I would have liked to see, for instance, this motion that was brought about in open court should have really been discussed ahead of time so you have a better position on it, but I don't want to waste your time. You want to do next hearing by Zoom? You want to do it in person? You tell me. Plaintiff?
We're agnostic, Your Honor. I'll do whatever.
We're agnostic? Is that what you said?
Yeah, as it relates to that, we'll come in person or we'll do it via Zoom.
Defense?
Your Honor, we prefer to be in person.
Okay.
Either way, Your Honor.
Okay. All right, we'll do it in person. Fine, we'll do it down here in Plymouth. I will be moving into the Brockton court next month, but this is especially assigned, at least for now, so I'll come back down here. That's not a problem. Mr. Clerk, do you want to suggest a date for us?
Sure.
How many days out you want to go for? 60 days, 90 days?
Yeah, probably 60 days.
50 days? November 21st, Friday in the end of November.
Yeah, that November 21st. Okay, I'll have a decision out before then, certainly, as quickly as I can. 11/21, and that would be for a status regarding tracking order and discovery, and any motions, Rule 15 motions to amend that or bring in third parties. Okay, all right, thank you, folks. We'll see you then.
Thank you, Your Honor.
All right. Nothing with the jury?
I don't think so.
Okay, that was absolutely fascinating, especially in light of what Margaret, the little legal class that she gave us beforehand, which put everything into context. So really appreciated that you did that. That made it, that really, really put everything into, I have some questions for Margaret that hopefully we'll get to, but first I just want to give Matt and Kate a chance to react since you guys didn't get to talk as much earlier. Did you guys have any reaction to any of that? Kate?
Yeah. Well, this is what I was talking about with the publicity stunt, right? And I'm glad that the judge kind of called it out and said, like, hold on, that's not really how we do things, and kind of chided them for being civil. I think he was probably pretty cognizant of the camera and being, quite fair. Like I said, he's a fair-minded judge, but that was completely improper, right? They're trying to drag 10 other people into this, allegedly, but they haven't filed anything, nor have they even noticed the other side. But they forgot to tell the O'Keefe attorneys, but they didn't forget to tell Howie Carr and Turtle Boy.
Yeah, right.
Right. Right. It's appalling. It's absolutely appalling at this point.
Mm-hmm. Matt?
Yeah, I mean, I think that the lawyer did a really good job explaining, the case high level, and she looked a little uncomfortable. I just don't know, like how he's explaining how long it's going to drag out. I'm like, are they really even going to get a benefit over time? How much are they paying for their lawyer? I mean, I think they should just hire a hitman, to be honest.
What a gigantic...
Don't say that. You get charged with something these days, let me tell you.
It's a joke.
What a gigantic team on the other side, though, right? I mean, that's just an incredible amount of lawyers, not even counting the bars. I mean, the number of lawyers that have latched onto this case, just so they can get their name attached to it, I guess. Just unbelievable.
Yeah.
On the defendant's side.
That's gross.
So the thing that caught my interest, Margaret, was the consolidation issue. If you can go to that. Now, they're talking about consolidating cases that haven't even been filed yet on the part of the defendant.
Right.
Can you talk to us about that a little bit?
Yeah. I mean, they're talking about consolidating so that, that because it's the same facts that we're dealing with, that they're arguing that all the cases should be consolidated against, the cases involving the bars. And then there was also the affirmative defenses that Karen plans to raise. And that's that, well, this was all a big conspiracy against her and a big cover up to frame her. Therefore, she should actually be the one that gets money out of this, and she suffered emotional.
So is she planning to sue? Is that what she meant by that? Those cases?
Yeah, those are called affirmative defenses. So you can actually allege a affirmative defense in this particular lawsuit. So basically, and the jury would have to decide. So it's almost like in a football game where she's like, okay, well, these are my claims. I deserve money. And that they all should be consolidated. Right. And I've tried cases like that where the defendant will come up with an affirmative defense that the jury must decide that as well. Well, the jury may think, well, we don't think that Karen Reed caused John O'Keefe's death. We don't think she's responsible for his death. But, maybe she's the one that deserves money because she was framed by all these police officers, et cetera, et cetera. So you never know. A jury could decide in favor of Karen Reed. That's why jury selection is so important in this type of case. So those are some things that can happen in these cases. Now, I noticed at the end that the judge, in all civil cases, the judges will really try to get both parties or all 10 parties to talk about it and to resolve the issue. So they're always pushing for settlement. So maybe parts of the case will settle. I wouldn't be surprised if the cases involving the bars will settle, because remember, behind the bar, each bar, okay, is a big insurance company. And that's what I did. So I worked for the insurance company, and we would settle all these types of, the premises liability. I'm sure when you owned a bar, Kevin, you also had to be insured, right?
Oh, yeah.
Anything that happened.
Absolutely.
Yeah. And you would have part of that contract of insurance is you get representation by the insurance company. So
Kate,
I don't want to go on and on. You have to stop me, Kevin,
mean-
because sometimes I go on these things.
Margaret, do you feel like they're going to be successful in kind of roping this in? Because the judge sounded pretty skeptical.
You mean in the defense motion to dismiss these 3 counts?
No, so they haven't filed a joinder, I think is what it would be, where they're trying to assert their affirmative defenses and essentially say, well, now we want to bring in 10 more defendants. Like, I don't really that's confusing to me too, because it's like, right, like, I don't even know how, like, they become defendants all of a sudden. The O'Keefes are not suing them. They've done nothing to be sued for, right? So they essentially, I mean, it is sort of just like the most literal representation of her strategy the whole time. She literally wants to drag other people in, per her attorney's report today anyway, and say like, no, they did it instead. And I noticed the judge seemed kind of like skeptical about that.
Mm-hmm.
Isn't that more just because they haven't? Isn't that more just because they haven't been filed yet?
Well, he also, his tone about bringing 10 more people in was skeptical, and he said they were, from what he's hearing, it's novel arguments, which is
yeah, that's true. That's true.
Right,
yeah,
right.
that. Yeah.
A mild way.
Yeah,
of
it is
saying,
kind of. It is
Yeah.
the whole. Yeah, like the whole concept of the affirmative defense that Karen's been framed and therefore she wants to bring in whoever was involved in framing her in in their case, like it would be, I don't know, the McCabe's or the state police, Proctor, et cetera. So that could involve quite a number of defendants that Karen wants to bring in, and it would make the case quite interesting and complicated for the jury. I would think they would have to separate out each party. So, in a case like this, though, I think the judge would have to make a decision also knowing that I wouldn't be surprised if, to be honest, I don't know. If I were the judge, I would want to separate the 2 out, because I do think it's a lot. Right. It might be very confusing for jurors, but then maybe the judge will say, well, some of these defendants will drop off via settlements. So we'll see what happens. It is, it's quite confusing when you get into, civil lawsuits and affirmative defenses. It gets complicated. So.
Right.
I mean, I think that they're just doing it so that they can keep the grift going. They can keep talking about this stuff on YouTube. They can keep attacking the McCabe's and the Alberts. I mean, that's all it is.
Right, that too.
It's such a joke.
Yeah.
And the legal purpose for that would be jury contamination too.
Right?
Yeah.
Just to continue doing that.
Yeah.
It's been very effective so far.
Yeah. Trying cases in the media. So.
And there seems to be no safeguard against it. Or at least we haven't had a judge that stepped up and has done anything about it, or
right. I know. As far as sequestering, jurors, should they be sequestered these days? Because I do believe that some jurors very likely went home and watched social media on this case. How do you monitor that?
Is it apparent now that Judge Cannoni took no action after the trial? I mean, she almost implied, I think, that she couldn't take any action during the trial. She didn't want to violate Karen's Sixth Amendment rights.
Right.
And I agreed with that, and I understood that too. I think a lot of us probably understood that. But then again, all right, so why didn't you take some action after the trial?
I think that, like, especially like when I read that media order that came out this morning, read it before, but when it came out, I was like, wow, that kind of highlighted to me really some deficiencies with Cannoni, honestly, because like this is a civil trial, okay, and I'm not saying they're not important, but obviously, a criminal trial is the most. The stakes are the highest, it really needs to be upheld. It's just like, and she didn't bother to do, these are very simple steps that Judge O'Shea took within the bounds of law, right? He's not restricting access to the proceedings or anything like that. No gag orders at this point, just no filming outside the courtroom, no interviewing these people. And that was on court property. And that is enough, I think, to really curtail the circus, because why are people going to go down there if they can't film or be filmed, honestly, right? to jinx that, but like realistically, like that's why they were all down there in the first place. You know, with that media rule in place, Turtle Boy or someone like him can't pull the shit that he was pulling throughout the criminal trial, following the witnesses down, you know, yelling at them, demanding to know why they killed John O'Keefe without any evidence, following to their cars, all that. That's not happening now. And it was a very kind of straightforward, logical order that was put in place to prevent a lot of this. Right from the beginning, this judge is thinking about the possibility of jury tampering, of it, you know, all that stuff. Why didn't Canone ever do that?
I know, especially where she had in the courtroom Turtle Boy, someone who had been doing it on a previous trial. I forget the name of the case that was just not that far before that.
Yeah.
Chestnut case, yes.
Right.
But the Commonwealth didn't even ask for a change of venue, did they? I don't even remember them ever asking for that in the Karen.
No, and I wish they had.
Yeah,
I wish they had.
Yeah. But I'm just saying, something as simple and really uncontroversial as a media order like this, I think in theory is almost more effective than a buffer zone.
Yeah, you know, the problem with that is the media can oppose that, and they do have First Amendment rights and all that, so there would be a clash there. So it's a very fine line. Yeah, but I see what you're saying, and I feel that the law hasn't caught up with our modern day society and our you know, how fast everything gets online, and we all watch on YouTube, and the law is always behind technological advances. But something has to be done, because I agree with you, Kate. It just, how do you prevent somebody from you know, being a turtle rider and then getting on the jury, or even becoming a turtle rider as you're on the jury, which might have happened here.
And that's sort of like the end run for me, right? Like that's sort of like the end consequence with all this. But I mean, even taking the steps to prevent everything along the way that we saw. And I think somebody in the comments said this judge has the benefit of sort of like looking at the criminal trial and everything that happened out of that. I'm not disputing. I would agree with that. Although Canone had 2 trials, so she had 1 to look back on at least, and still didn't do anything differently. But either way, preventing the circus, I think, is as important, pretty important anyway, as protecting the jury, right? Like, because that circus was an abomination. It takes away from the operations of the court. It costs a ton of money. I think we've seen that come out, how much it costs the crowd control. It's harmful to the victims. It's harmful to the witnesses. It's disruptive to other people with their cases. It's disrespectful to the court, and it chips away really at the seriousness of what a courthouse should be, right? And so I was, you know, encouraged to see that Judge O'Shea is looking at that, and I'm discouraged that Canone really didn't at any point.
Is it surprising that there was no gag order requested for, especially given the points that the O'Keefe family attorney made about all the leaking to the media that went on from Karen?
I'll let some.
Go ahead.
I am not surprised. I am not surprised at this juncture, just because like gag orders are now we're wading into First Amendment territory, right? So I think the court's kind of reticent, and gag orders are not that, especially in a situation like this where you look at the history, how effective really are they? Because they can only gag the attorneys. They can't Karen, right?
You're 100% right, Kate. Yeah. So, and it did us no good. I mean, yeah, the gag order was in effect for the last trial, but Karen could talk as much as she wanted. And that made it hard because, you know, there was nobody really out there representing the prosecution at all.
Right.
You know, Hank couldn't say anything. Nobody in the DA's office said anything. It was basically maybe us, you know.
Because they can't, you know, they can't. And obviously civil attorneys now don't have that same constraint. So her attorneys can and have been speaking out. They have a blog. There's a little bit of media coverage. They make statements. They are speaking, and they're allowed to. I mean, you know, and then we kind of look at, well, you know, we haven't really gone through much discovery, it sounds like, right?
No.
So I suppose that in a civil trial, what you would want to do is maybe look for some protective orders, right? Filing, on the
Yeah.
discovery, filing some things under seal when they're sensitive. But I don't know who that's going to benefit more, whether it's the plaintiff here or the defendant, because, the trajectory of the plaintiff's case anyway is they're going to be pulling out some stuff that's pretty damaging to her, right? They're pretty much saying, like, we want to dismantle the conspiracy that you created.
Yeah, and they get to depose her too, which will be great.
Right. And we know there's a lot of evidence to support this conspiracy that she created, though. And that's just what we know about,
Yeah. So it'll be interesting. But of course, a deposition is taken in an attorney's office and, with all the lawyers present. So, and the judge is not there. So it's a deposition is not going to be something that we can watch on television.
Right.
We can see them after the trial though, right?
It depends if it's released. I mean, usually they're not released. I've never seen it in a civil case. I mean,
I've seen
as the trial
OJ,
is pending.
The OJ Simpson one was released. You can find it on YouTube now.
No, I know, but it was released as the case was pending. That was
no, as I said, like I said, after the trial.
After the trial, yeah. It'll be interesting, but yes. So civil discovery also takes a very long time. I mean, typically these civil cases take a good 2 to 3 years. I mean, think of all. They'd want to take depositions for all of the witnesses. So that would be, the people in the bar, the McCabe's, and all the attorneys will be there. So this discovery, and there's not just depositions, but there's interrogatory questions that must be, are filed as well. So there is quite a bit to civil discovery.
Right.
In cases
where anybody else?
Settled.
Anybody else?
I just think that our system is broken, and I just don't know.
Yeah.
I mean, if I were them, I'm like, would I even want to go down this or seek some other way? Not. I mean, I'm not saying that. Like, that was a joke, but like, I mean, publicly shame her, publicly put out all her information online. Like, we don't know anything about Karen Reed. We know everything about the Alberts and the McCabe's. Their entire lives were exposed. But Karen Reed, we only know what she said that one night. It's like such a joke. Why not go after her? Why not expose her?
Yeah, and here's the thing: the Alberts and the McCabe's have chosen not to really, for the most part, other than a few appearances, not to, go on YouTube like all her people have.
And,
so,
and
like,
there's some method to that madness too, right? That, without saying too much, because it's not like this is happening now, but I wouldn't say that the sun is going to rise and set on this particular civil case, if you catch my drift. So, there's reasons for that. That's all.
There are reasons, right? It's not because they're afraid to go on or something like that.
Or
there
guilt.
are reasons.
Right.
Yeah.
And just practically, I was telling
of course, yeah.
We can talk later, Margaret, and I think you probably already know or can surmise, kind of what they're avoiding right now. Right, or planning rather. But anyway, beyond that, practically just it's a giant Kafka trap. I was talking to somebody about this actually yesterday again, because it's one of my favorite ways to describe the free Karen Reed kind of machine now, as far as where they put these witnesses. It's in a giant Kafka trap where the question is posed, the accusation is made in such a way that even a denial then becomes evidence of guilt, sort of, because it's such an egregious accusation. Like if I said, Kevin, you're a P-file, right? And you were like, no, I'm not. I'm like, well, that sounds like something that a P-file would say. And everybody's like, yeah, no one would admit to that, right? And it suddenly becomes evidence of your guilt, even though it's not really evidence at all. And that's the position these people have been put in at this point. They can get up on any channel and say, like, we didn't kill John. And it's the truth. I mean, it's the proven truth at this point, as far as I'm concerned. But it doesn't matter, because then, these people turn around and say, well, of course, they're the murderers and they don't want to get in trouble. So they would say they didn't kill him. And, why did they have to come on TV to say that they did? So there's nothing for them to say at this point, really. There's nothing that they can say. And I would anticipate that at some point there will be something for them to say, but it's not now.
Yeah, I'm not sure I 100% agree with that. I do think that there are legitimate sound reasons for not doing it, but I do think there is some benefits for doing it too.
Right.
You get on there and explain your side of things, because it's only been one side that is out there all the time. And so this is what you get in the media, is you're getting a one-sided coverage of things. And unfortunately, it'd be great if you had other powerful people represent in the media that would represent this side that would go out there, but we don't have that. So that puts the burden on and the pressure on the witnesses to do that. They're the only ones that could get the media attention to do it. So, it's complicated, but I mean, I do think there could be a potential benefit to doing it, and but those are difficult decisions. So,
I think that the burden, unfortunately, as far as that goes, is kind of on, and it's not fair. I'm not saying that this is fair, but as far as the narrative and the truth, you can discredit people, and they've certainly been set up to be discredited, but evidence a little bit harder to, black and white. So the burden kind of does fall on the O'Keefe family and their attorneys now through this civil process, through discovery, because, people need to understand what happened and why it is that they were led to believe that these innocent witnesses are murderers in the first place. And in order to do that, it's not so much these people that they suspect, their word, it's Karen Read's own words, right? Her communications, her, and so unfortunately, not that they deserve any ounce more burden than they've already had to bear here, but that does kind of fall on the O'Keefe family and their lawsuit.
Right. Okay.
So we have
anything else?
Go ahead. We have an interesting, I just got, it'll be an interesting segment on Court TV tonight. I just got it. So from 9 to 9:15, it's me and Wayne Dennison. Topic: Karen Read civil case. How strong is the O'Keefe's case? So that's pretty broad, right? I'll have to narrow that down. And then Nick
Are you going to give
Rocco
us a sneak preview?
Not yet. Nick Rocco and Wayne Dennison are on the second block. How strong is Karen Read's case? So that ought to be interesting. The
Nick
affirmative
Rocco.
defenses. Nick Rocco, yeah. And
He's
then
a lawyer?
the C block is Rick Grundy and me. Does the plaintiff need to prove that Karen Read hit John O'Keefe? That'll be interesting.
Why are they still doing this? I thought that at some point that these networks would look at the damage that's been done and reevaluate a little bit. I feel like some people in that network have maybe even said something to that effect to the family without naming names. So it's very upsetting. So how strong is the plaintiff's case? Well, we only know the bare bones of it. How strong is her case? Right now, she doesn't have one. She's filed nothing.
Right. I know, but hypothetically. So I think, what, it's all, Kate, it's all about the numbers.
It's so disheartening though, because at some point, you have to worry about what you're doing to people and society as a whole. The media is just the enemy of the people. I'm sorry. This is a civil case, right? Like, we are literally going to pit this man's grieving family against Karen Read's conspiracy theory, and at some point, when does the coverage shift? When is there?
Yeah, but Kate, here we are talking about the same thing. So, here we are talking about the same thing.
Well, we'll see what Nick Rocco brings up. I don't think it's exactly the same thing. He's going to bring up some wild stuff.
The topic.
Not even close. I don't feel like
he's not going to be challenged because the host and Wayne Dennison are on the same side. So
right, exactly. And again, we're not, are we discussing the civil case? Yes, as it's happening. Do we have some understanding of where it at least is being brought, probably, or they're attempting to? Yeah. At this point, what do they mean by how strong her case is? She hasn't even gotten leave to drag in the other 10 people that she wants to point the finger at. That's not even an issue right now. And why are we yet again giving airtime to this ridiculousness at this point?
Well, I think the airtime makes sense if you're talking about what Margaret was talking about before the show, and it was all relevant in terms of the legal issues.
Right.
But there's no new evidence that's been subjected here, so we're just going to hear more, BS about Brian Higgins and phone calls and dog bites. Well, what does Nick really have to add? I'm not trying to be but what does he really have to add? There's nothing that came out in court today that a non-lawyer should be on there talking about, I don't think.
What do these topics have to add at some point? You know what I mean? Rather than discussing the procedural stuff, or, I suppose that you could broach the subject of what at least the plaintiff's attorney brought up today regarding, her actions, and more importantly, the conspiracy surrounding, everything after the fact, I guess. But it doesn't give a lot of room to even really speak the family side at this point, because yet again, it's like pitting, how strong is this versus how strong is something that hasn't even happened yet. I mean, I don't know.
Yeah.
It's just frustrating to me that yet again, it's like we're pandering to Karen Reed. Why? I can understand people not liking the police, especially defense attorneys that frequent court TV. Great, like sort of your job. I get it, but like this is not.
Well,
Karen-
it's not even that they don't like the police. It's that their job is to make it seem like that because they're trying to get clients.
Yeah, I'm sure that some really don't. I've met some that really don't. That's fine.
Well, maybe, but I'm just saying they're primarily defense attorneys. So
right, but this is no longer Karen Reed versus the system. Now this is Karen Reed versus the grieving family. I don't know. We'll see how Vinnie Politan handles it. I guess maybe I'm preemptively getting annoyed, but I don't think that I am. Honestly, I don't. It's like, it feels soulless to me at some point. I mean, I think it's unfortunate that it's being televised. The nosy part of myself appreciates that. I could have gone down there if I really wanted to, but I don't want to. I just don't want to. It's all the way in Plymouth. But like, regardless, like the nosy part of me appreciates that it's televised, but the human part of me knows that it's kind of wrong. It's kind of wrong, like at some point. This doesn't have to be fodder forever. These are real people that lost someone.
Well, I appreciated learning a lot about the system today, especially what Margaret had explained beforehand, and then seeing how that was played out in the hearing. I would have been lost without Margaret's explanation beforehand. So I do like to learn stuff. So I did appreciate the hearing, being able to watch the hearing from that point of view.
I'll try to sound intelligent. It's funny. I was looking at the comments and somebody just said, what was it? Somebody said, well, Margaret might still be hungover from her daughter's wedding. That's fair.
Are you?
No. But I've lost my voice a little bit. I've lost my voice a little bit. But actually, I mean, I was sick like the week before my daughter's wedding, but if I still sound a little hoarse, but that's kind of sexy, right?
I don't think you do. I look more hungover than you do, honestly. I'm not, but I mean,
God.
I wish I was hungover. Or I wish I could have at least had the thing that leads to the hangover. But
it's funny. Well, yeah, no, but I do enjoy, I think we had a nice discussion though on the law, and I appreciate what you've been saying too, you guys, Matt and Kate. I think it's very relevant, very relevant,
Okay,
but this nation is still obsessed with Karen Reed. I mean, Kevin, you and I have talked about it. Even the numbers for our shows show that.
Yeah. Yeah. I don't want to do shows unless there's something new on it. And if there's something new that needs to be done, I'm still digging, as is Kate, at different angles into the Fed aspect of this.
Yeah.
So, we're finding out, for example, that the FBI and the U.S. Attorney's Office does not seem to have ever questioned any of the first responders, any of the local police, with the exception of Devers. And Devers, Officer, is it Dever or Devers? I forget. Officer Dever had, she had sought them out on her own. Is our understanding of it.
Right.
So why is this? Why would the U.S. Attorney's Office or the FBI have no interest in what Officer Goody saw that morning when Brian Higgins came back to return the cars, to move the cars around in the parking lot? Why would they have no interest in this? If the feds had any interest at all in the truth, why didn't they pursue any of that? And it doesn't seem that they did. So this is a case that does involve a conspiracy to a degree. Maybe that's not a word that we like to use with it, but it does involve corruption, and it's from the federal side. And that's an extremely powerful, you don't get much more powerful than the U.S. government. Right. So this is something we have to get to the bottom of, and we're still digging. And, if I only have to do a show on that once every 6 months when it comes out, I'll do it, But when something comes out, I'm going to cover that.
Yeah. Anything new on the federal government, Kate?
I mean,
you've dug up.
Well,
revolve, on Karen Reed.
As far as like what happened, no. I mean, that's the thing is like, you kind of, it's hard. It's a veil that's hard to pierce. I'll put it that way. And
Oh,
so
yeah.
at this point, I think that, there's a lot of stuff going on in the background that I really don't think that anyone would appreciate if I was talking about in public right now. But, it's a process to try to pry information out of the federal government. It's more of a process when perhaps there's been some misconduct, as we're kind of assuming here. And certainly the reaction to certain things would, support that anyway, right? At this point. And then, there's some other, I don't think I can even say anything. I will say that I feel hopeful about Foley's administration.
Well, I've got something for you, Margaret. I don't think I've told you
Okay.
this one before. All right. I don't think I haven't told this. I've reported it briefly on the show. So Matt, this will be his first time hearing this too. But so obviously Josh Levy was the U.S. attorney, and with the change of administration, he was out. And then there's a transition period before Trump names a new U.S. attorney. And what was put in place was someone named Mary B. Moraine. So she goes from the assistant U.S. attorney to the acting U.S. attorney for a couple of weeks there, until she is eventually replaced by the Trump appointee, Leah Foley, who we have hopes for, but also the degree of skepticism as to whether she's going to pursue the truth here. Well, now Moraine left the job. She left the U.S. attorney, Boston U.S. attorney's office after, and she's spent many, many years there. And she not only left the position, she left the agency. So what happened to her? Where'd she go? Well, I found out that where she went to, she is now working for the Department of Justice in Washington, where she can presumably watch Josh Levy's back. That's a little bit of a leap of assumption there, but it's still very strange I've talked to other people in the feds that find it very strange that she ended up there.
Yeah, I agree with you.
So I don't remember if I had told you that before, Margaret. Maybe I did.
Yeah, it is strange. Yeah. But the listeners haven't heard that. So
yeah, I think I had mentioned it once on the channel, but we only probably had about 25 people watching. So
and how many do we? Yeah, we probably have a lot now because it's Karen Reed, right?
Yeah, we've got about 400, so we've got more watching. All right, so unless there's anybody, I'd like to call it a day if it's all right with you guys. I want to start getting ready for.
I got a couple phone calls to make. I'll catch up with you later, probably, Kevin.
Okay, thank you. Great to see you, Kate. It's been a while, so good to do a show with you.
It was really nice to see you, Kate.
We'll be doing something
Matt.
soon, Margaret. And Matt, good to see you again.
Me too.
Oh, guess what, Kevin? The Scituate police called back on that case, the 1944 case, and
we are still live. Just to let you, just to make sure you know, we are still live. If that's okay.
Yeah, no, that's okay. The Scituate police called back on that unsolved case from the World War II era.
Good. Yeah.
So I got to call them back.
So they're going to set up a meeting probably, and hopefully they'll have some evidence.
That'd be cool. So we'll see.
That'll be awesome. All right. Well, good to see you, and I'm glad you're feeling better. And
thank you.
Let's get to work soon.
Okay. All right.